Hi, I'm Barry Forbes, Staff Counsel and Associate Executive Director of the Wisconsin Association of School Boards. And this video is on contract revocation, renewal, non-renewal, and the annual report to the Department of Public Instruction and state legislature. Wisconsin law specifies the reasons that support a school board authoriser's decision to revoke or terminate a charter school contract during its term. The charter school may have violated the contract. Students at the charter school are not performing at the level required by the charter school contract. The charter school's financial management fails to meet generally accepted accounting standards, or the charter school violated the charter school law, section 118.40. A brief explanation of the difference between revocation and non-renewal is warranted. Charter schools may contract with a school board or other authorizer for terms of up to 5 years. If a school board authorizer seeks to end a charter school contract before the expiration of that 5-year contract term, the board is revoking or terminating the charter school contract. At the end of the charter contract term, the charter school may seek a renewal of the contract. A board decision to allow the charter school to complete its contract term but not be given a new contract is referred to as a non-renewal. If the school board authorizer and charter school agree to renew the contract, the new contract can have a term of up to 5 years. NACSA principles and standards provide guidance on how decisions regarding contract termination, renewal, and non-renewal are made. Authorizers should follow a merit-based process in renewing or non-renewing a charter school, focusing on student achievement, contract compliance, sound fiscal management, and protection of student rights. School boards should address how contract termination, renewal, and non-renewal decisions are made in board policy. Underperforming charter schools may have significant political support, and supporters may argue that the popularity of the charter school is itself a reason to renew the charter. A well-drafted school board policy describing how decisions to renew or non-renew charters are made will help the school board make its decision based on the merits of the renewal application. Board policy should address the process and timeline for charter school renewal applications. The Madison Metropolitan School District requires that applications be submitted at least 8 months prior to the expiration of the contract. The Green Bay Area School District policy statement on charter school contract renewals requires applications 6 months prior to the expiration of the charter and identifies performance standard required by the charter school for renewal. The Milwaukee Public Schools policy on charter schools sets forth a process for contract revocation that starts with a request from the superintendent, followed by a public hearing held by the school district's licensed review team. Written recommendations are submitted to the school board, which will make the final decision. The MPS policy identifies the grounds for revocation of the charter school, which track the provisions of 11840(5). The Madison Metropolitan School District policy statement on grounds for contract revocation include the 4 reasons identified in the statute. That's the charter school violated the contract. Pupils in the charter school are failing to make sufficient progress. The charter school failed to comply with generally accepted accounting standard, or the charter school violated the charter school statute. Those 4 reasons, and then they add a 5th for good cause. This slide starts a brief review of the authorizer annual reporting requirement. Charter school authorizers must submit an annual report to the state superintendent of public instruction and to the state legislature. The law does not specify any exceptions, which suggests that all authorizers must submit the report, including the school boards that have never authorized a charter school. The Department of Public Instruction has not issued rules interpreting this requirement, so it is not clear if school boards that have not authorized a charter school and have nothing to report are required to submit a report. The report must include the following information: identity of each charter school authorized and under contract, charter schools with contracts that were non-renewed or revoked, or where the charter school closed, and the authorized charter schools that have not yet opened, and a report on the academic and financial performance of each of those charter schools. The report must also include information about financial costs incurred by the authorizer and the performance of its duties as the authorizer, with a detailed financial statement, and a list of the services that the authorizer provided to the charter school with an itemized accounting of those costs. The Department of Public Instruction website provides technical assistance and a report template that can be found on the Department of Public Instruction website at the link you see on your screen. This ends the section on contract termination, renewal, and non-renewal, and annual reports. School boards with questions can reach me, Barry Forbes, at bforbes@wasb.org or 608-512-1707.